order the South Subcommittee, or the House Subcommittee on House Study Bill 28, bill with respect to public agencies' disclosure of certain personal information. And I'd like to just, generally, I'm here with Representative Holt, who's standing in for Representative Wheeler. Appreciate it coming on at short notice. Also with me is Representative Bohannan. And so just like to start, if we want to start over there, if you have something to say, please introduce yourself. If you'd like to speak to the bill, make sure you step toward the table though, so everybody can hear you online. So, okay.
Mr. Chairman, Brad Hartcup with the Iowa Association of Business and Industry. We're registered in favor of the bill. Appreciate you bringing this forward. We believe it's an important piece of legislation. Thank you.
Thank you.
Caitlin Jarvin with the Judicial Branch. We're registered undecided on this. I have to start by apologizing. I have an amendment. I was going to bring paper copies. They're sitting on my desk. They've been emailed to everyone on the subcommittee though, and for everybody else, they're posted in the public comments, so you can find them online. So like I said, we're undecided on the bill. We do just have a couple little implementation issues, and these are the same issues we've talked about the past couple of years. Iowa Code 602-1601 says that all judicial branch proceedings shall be public unless specially provided by statute. So this makes filings from both parties accessible to the public. Now I understand there's just a discovery exception in section 3 and an exception for court-ordered inspection of records in section 7. However, there are many ways besides discovery and court orders for records to be included in a court file. So for example, a filing party, a filing from either party could contain personal information regarding a 501c3. Now, according to Court Rule 16601, it's the responsibility of the filer to redact. However, if the filer doesn't redact and the document contains personal information, we don't want our clerks to be on the line for that. So because the document would be made available by the clerks pursuant to 602-1601, we don't want them to be put in a bad spot there. Now, HSB 28 prohibits disclosure of personal information, including in court files, unless there's written permission from every member, supporter, volunteer, donor. So for a 501c3, like United Way, for example, this would be thousands of people. Now, we're not opposed to the policy of protecting that information, and we're not opposed to the bill. We simply want a means to protect the information that we can practically implement. So our proposal is to protect the clerks of court. We propose an amendment that adds another exception to section 3 for disclosure of personal information in judicial proceedings that are public. To protect the personal information of the 501c3s contained in case files, we further propose that the 501c3 may petition the court to seal the case file that contains the protected information, and that upon petition, the court shall do so. Thank you.
Thank you. Who's next? Okay.
Mr. Chairman and members of the subcommittee, thanks for allowing us to testify. I'm Chuck Hurley with the Family Leader. We support HSB 28, believing that those who give donations to nonprofits should have the right of privacy for their charitable giving to causes they believe in. Anonymous donations to charities are deeply ingrained in our nation's culture of giving for reasons such as humility, religious obligation, a desire to avoid future solicitations, limiting family strife, etc. Unfortunately, not everyone respects the privacy of charitable givers. In particular, some politicians and activists seeking to target those who disagree with them. In response to this threat, Iowa's legislature should protect nonprofit donors by passing this bill. It will not roll back Iowa's laws requiring disclosure of campaign contributions or harm fraud investigations of nonprofits. The only two things it does are: one, prevent government officials from abusing their power by demanding the donor list of nonprofits, and two, prohibit disclosure of personal information connected to a nonprofit that may come into the government's hands. The bill would ensure that politicians can't intimidate a group for, by example, denying government contracts to the group's support orders, releasing donors' names to the public in an effort to encourage intimidation or retribution against them. This is the main thing I want to share with the subcommittee. There is a long and very important history of people using donor information to have people fired, their businesses boycotted, and worse. That's why the Supreme Court in 1958 ruled unanimously in a First and 14th Amendment case that the state of Alabama could not require the NAACP to turn over its membership list. I strongly urge everyone who's interested in this issue to read the sordid history of racial injustice that was rectified by that case. Here's a very brief quote from that amazing decision. Listen carefully. A requirement that adherents of particular beliefs wear identifying armbands, for example, obviously interferes with freedom of assembly. When government agents compel disclosure of membership in an organization engaged in advocacy of particular beliefs, it is the same. Protecting privacy in group association is indispensable to preserve freedom of association, particularly where a group espouses dissident beliefs. 5 years, 5 times up to the Supreme Court level before we got that decision. The oppression in Alabama was horrific, and it was rectified. So, in conclusion, given our current political climate, many donors hesitate to give to a group that other people see as controversial if their donation may be made public. Iowans are no stranger to anonymous giving, whether it's tens of millions of dollars to support immigrants or other controversial causes, or numerous small anonymous gifts made through sites like GoFundMe. This bill would ensure that those and countless other acts of concern and kindness can remain private if the giver wishes. Since Iowa wants to continue to encourage giving, passage of this bill should be a priority. Thank you very much.
Thank you. And who's next? If anybody else want to speak toward the bill, we'll kind of move around the room. Okay.
Keenan Crow with One Iowa. We represent LGBTQ Iowans. We are in favor of this bill. It's very odd for Mr. Hurley to go up and speak and then have me go up and speak and say, I agree with Mr. Hurley. That's something that you don't see very often. But we believe that this bill is important enough that we're going to put our name behind it. Obviously, when you have an issue like LGBTQ rights, it can be controversial. We promise our donors that we'll maintain their privacy, and any attempt to disclose them would obviously be us breaking our promise to our donors inadvertently, and that's a big problem for us. So we support the bill. We hope that it advances. I realize there's all sorts of concerns about dark money and things like that, but the basic principle here is just that we're making the promise to our donors. We want to keep that promise.
Thank you.
Thanks.
Good afternoon, Mr. Chair, members of the subcommittee. Matt McKinney on behalf of the Philanthropy Roundtable. We are registered for this bill. I won't rehash the words that were shared there. They were shared very eloquently and make very good points. Our concern is we want to maintain privacy, just like you've heard. Without privacy, you risk contributions, risk the ability for people to make charitable contributions, to participate in their community, to work with family foundations and others. And so it could have a chilling effect if people don't believe that there's privacy as it relates to that. Also, the donor harassment piece that Mr. Hurley referenced, that's very real. People are concerned that if lists are out there, they could be targeted for additional funding. Hey, this person's contributed here, and so why don't we seek to see if they can contribute to this organization or as a part of some sort of retaliation. And then finally, anonymous giving, as was said, is sometimes it's the highest form of giving. Sometimes it's the most meaningful giving to folks. And if people do not have assurances that there can be anonymous contributions, then they very well could cease contributing or lower their contributions. So thank you. We are supportive of the bill.
Thank you.
Victoria Sinclair with Iowans for Tax Relief. I want to thank you for having this subcommittee. I want to open by saying this is a First Amendment issue, and I encourage you to look at the registrations on this bill. Most of the groups registered on this bill participate in some of the most contentious debates of every session on all sides of the issues. Our members donate to our organizations because they believe in our causes, whether they do not personally have the time to promote the values our orgs espouse, or they fear persecution for holding a view that may be unpopular. Individuals donate to our nonprofits as a representation of their freedom of speech and association. I'm confident in saying that I am not the only person speaking in favor of this bill who has been personally attacked for representing our members and our donors' views. I know I've been chased out of this building by individuals shouting at me. I know others who have been spat on or had to be escorted to their vehicle by a state trooper to ensure their personal safety. This is an occupational hazard that we've all taken on to help advance the causes of our members and our donors. But our members should not have to fear for their lives for holding a view that may be unpopular at any given time. Organizations take steps to protect us in our offices, but our donors are soft targets. Releasing their names and addresses at best makes them a potential target for harassment, and at worst, it puts their personal safety in jeopardy. By failing to pass this legislation, you're effectively chilling free speech. I'll remind you that what seems contentious today may be tomorrow's accepted norm. As Mr. Hurley mentioned, this was the case with the civil rights movement. Perhaps had the supporters of equal protection of the law been doxxed during the 1950s civil rights movement, the world may look a lot different today. I want to thank you for holding this subcommittee, and I encourage you to protect our First Amendment rights and advance this legislation.
Lohse.
Thank you for bringing up this important issue. Bill Gustav with Homeschool Iowa, and I also registered for personal interest because I'm a lawyer with Hagenau and Gustav in Des Moines here. My practice is, one of the primary areas of my practice is nonprofit law. So I have several clients who this would apply to. And I've personally been a target, as Victoria mentioned, I've personally been a target. I will be again for my speech. I know it's not popular with everybody. I'm willing to step up and take those arrows and do that sort of thing. I represent a lot of nonprofit clients that set up organizations that are willing to step up, have people willing to step up and take those arrows and be that foil. But they have others who want to support the cause, and they're concerned about people showing up at their house, threatening their children, threatening their families, threatening their businesses. So this is a good, important protection to bring into our law that will protect them. And the concern here is, as Mr. Hurley mentioned, is abuse by government officials, and it's targeting speech. And unfortunately, it's targeting a specific type of speech, political speech, which is particularly heinous. And finally, I'm looking at that. When I look at the registrations on this bill, anytime you get somebody who's a conservative, libertarian-leaning person in the ACLU registering for it, and One Iowa, and Family Leader registering for it, you know this is an important civil liberties issue that we're all concerned about. So thank you for taking steps to protect this.
Thank you. Representative Bohannan, do you have somewhere to be at 12:30?
I'm sorry.
Do you have somewhere to be at 12:30?
No.
Okay, I just wanted to be cognizant of your time and as we're running a little.
No, I
long.
usually schedule a little more than 15 minutes for
All right.
these things.
Right, thank you. Who's next?
Julie Smith, I'm representing the Philanthropy Roundtable with Matt McKinney, and you heard Matt's great comments that were for the bill. Thank you.
Great, thank you. Anyone else want to speak toward the bill? Okay, I'll open it up. Representative Bohannan, if you have any questions, comments, anything you'd like to add?
I do, yeah, thank you. I appreciate everybody speaking. I agree that it's kind of nice to see agreement on a bill like that from different sides of the spectrum, so that's great. I do have some concerns. So I'm generally really supportive. When I first saw this bill, I thought that this was going to be adding another exception to the confidential records exception in 22.7 of the open records law. And so I was supportive of that. It made total sense to me. But then as I started to look at it, I realized that this isn't just creating another exception to the open records law. It's creating a whole new scheme for this particular kind of information. And so that gives me pause. So if you look at, the open records law is there for a reason. We do require transparency and openness in government, and for most government documents and other types of documents to be open that the government relies on in its work. And so we do have a large number of exceptions in 22.7. that basically it says the following public records shall be kept confidential unless otherwise ordered by a court, by the lawful custodian of the records, or by another person duly authorized to release such information. And then it contains, right now, 73 exceptions to the open records law, and it lists things that should be kept confidential under ordinary circumstances unless ordered for some reason. And those include things like personal information contained in a student record, so school kids, school records, university school records, also hospital records, people's personal, health information, which we generally think of as very, very confidential. Trade secrets, so things that businesses really hold very close that are very important to them in their business, that a lot of times businesses are based all around one trade secret, one thing. Attorney work product, also very heavily guarded, considered to be confidential. These are all things that are part of the usual scheme in 22.7 of creating an exception, but there is the possibility of a court order bringing it out, or agency having to disclose it along the lines of, I think it was the judicial branch person, that sometimes these things just get disclosed in the context of judicial proceedings and things like that. And so I'm concerned that we're creating a completely different rule here for this one kind of information, and I'm worried about unintended consequences along the lines of what the judicial branch brought forward, that there might just be times when through the ordinary work of the judicial branch or through agency work or something like that these things get disclosed, and then, this is we're just treating this in a much more strict way than we are these other things, which I think have very weighty claims to confidentiality as well. And so I just, like I said, I would be a lot more comfortable if we were just creating another exception to the open records law, but this is a whole new scheme, and I feel like it upends sort of the general framework here. The other thing, just to add to that, is the penalties. There are actually criminal penalties here for this disclosure, and that seems pretty severe to me, when again we don't have that same kind of thing in general open records law. So I am really concerned about those unintended consequences and tying up agencies and the courts and things in their work, and what might happen if we create a whole new rule for this different than what we have before.
Anything else? Okay. Representative Holt.
Thank you. Check this also so people can understand me. So I green-lighted this bill a couple of years ago. It had bipartisan support, and we could see in this room, and if you look at the registrations, no one's registered against this bill. You've got organizations from all sides of the political spectrum that are registered for this bill because they see the importance of donor privacy. And what convinced me that this bill was so important to do 2 years ago was the case that Chuck Hurley referenced with the NAACP, where I believe it was state courts that said, yeah, open these records so that people that were supporting the NAACP could be targeted, and horribly targeted. And it took a federal court finally to say, no, we're not going to operate this way. That was horrific. I don't think it couldn't happen today in the political environment that we are in, on either side of the spectrum. So that is why you can see groups as diverse as One Iowa or the Family Leader that are supporting this. And I think it's great because they see the importance of protecting donor privacy. And yeah, I'm all for these severe penalties that Representative Bohannan references, because I think back to the NAACP case and the consequences and the possibilities of what could happen if this information does get shared and people use it to retaliate against individuals. So again, look at who's registered. Nobody against. You got Association of Business and Industry, ACLU, Philanthropy Roundtable, Iowa Safe Schools, One Iowa, ITR, all are registered for this bill from all sides of the political spectrum, because it is that important. All you gotta do is go back and look at that NAACP case, and that absolutely convinces me. So again, we tried to pass this a few years ago. One representative who is no longer with us. It had strong support on both sides, Democrats and Republicans. One representative who's no longer with us, frankly, just tried to turn this into a political football. That's the bottom line of what happened. And so we had to pull it off the floor and not run it. I would hate to see that happen again. because this is a piece of legislation that should be bipartisan and should, in my opinion, pass with 100 yeses up on the board, because we need to value privacy, we need to value and understand history and what happened when that NAACP case. So that is why I green-lighted this again. I'm hopeful that we can pass this legislation, because I think it is very, very critical and very, very important for all sides of the political spectrum. So again, I'm going to be supporting it, and we'll see what happens. Thank you.
Thank you. I agree with your representative, Holt, 100%. I actually live in this space as a donor. My family and I give a lot of money to various organizations. And one of the things that, you know, especially for my kids' safety, not so much me, I really don't care, but it is important that, you know, where my kids are involved, because they are listed as donors in different locations. And their safety is primary, where they don't want to be known, and their disclosure, their ID does not want to be disclosed. So, but I think the most telling thing about this bill, one, it's been around for 2 years. We vetted it for 2 years for potential loopholes. Obviously, unintended consequences is a big issue. We want to make sure we close as many loopholes and cover as many bases as what we can. But we've vetted it now for 2 years. We're bringing it back with the amendments requested from the judicial branch to close a couple things that we kind of missed, and made sure we vetted that issue. But when you look at the list of those that are in support, anytime you can get this long list of very diverse opinions, all in agreement, it tells me it's a good bill. So I'm in support of it. I'll certainly sign off, move it in committee, but I agree this is something that should be bipartisan, and we should have tremendous support on the floor for, because safety of donors is a vital issue. So. Anyway, so yeah, I'll be signing off the move. I suspect.
Can I ask a question? I'm sorry.
Oh,
Go ahead.
sure.
No, so the amendments you mentioned, are those the ones that she mentioned that we haven't seen yet? Is that?
They should be in your inbox.
Okay,
So,
okay,
yeah.
sorry, I haven't.
But we will
I've been
certainly
in
get a
meetings,
copy
I
to
haven't had
you.
a chance to check things
Yeah.
yet, so and you're supportive of the amendment, so I want to.
Yes, we are.
Okay, so I'm not gonna sign off just now. I might very well get there. I'm very, like I said, I am really, really taken by the fact that there is broad support on sort of different issues. So I'm not saying no at all. I just want to take a look at those and.
Absolutely, fair enough.
Yeah.
All right,
Okay.
thank you. All right, that'll conclude.